August 6th, 1991. Jeffrey Dahmer enters the courtroom for his second live broadcast appearance. But if you look past the media spectacle and pay attention to the background details, the official narrative starts showing real cracks. Notice the officers escorting Dahmer. Keep your eyes on the black officer leading him in, and pay close attention to the white officer directly behind him. As camera cuts shift throughout this brief sequence, the seating arrangements and positions of these officers behind Dahmer inexplicably jump around. Look at the black officer seated behind Dahmer later in the shot versus the initial entrance. Are we watching a single, continuous live hearing or edited footage stitched together from separate takes and rehearsals?
Assisted by Carol White and Assistant District Attorney Greg O'Mara. With us at council table is Milwaukee Police Department Captain Donald Domagalski. He is the complainant in the amended complaint.
Afternoon, Your Honor. Attorneys Gerald P. Boyle and Wendy Patricus and Scott Hansen appear on behalf of Mr. Dahmer. He's present in his own person.
We are here this afternoon based upon the amended complaint that the state's filed with the court.
On today's date, we are filing a 12-count complaint, 12 counts of first-degree intentional homicide. We presented earlier to the court.
And you received that, Mr. Boyle?
Your Honor, we've received the...
Your Honor, I have in fact met prior to this hearing.
Mr. Dahmer?
Yes, Your Honor, that's correct.
As to counts 1 through 8, you are charged with first-degree intentional homicide, which carries a life imprisonment penalty. In addition thereto, you're also charged in habitual criminality, which carries an additional 10 years on each count. Do you understand that?
Yes, I do, Your Honor.
You also understand the nature of these proceedings, the complaint itself.
Yes, Your Honor.
You also understand you have a right to a trial by jury and a right to a preliminary examination.
Yes, I do, Your Honor.
And you've discussed that with your lawyer also.
Yes.
If it please the court, at our proceedings on July 25, the court set a date for a preliminary hearing of August 22nd, 1991. That is, of course, was beyond 10 days, and there was an appropriate waiver. The amended complaint, if we continue with the preliminary hearing, I think we will need another waiver as well, so that we have no question raised about the denial of a preliminary hearing within 10 or 20 days.
Mr. Boyle?
We have now added 8 additional counts, so there are 12 counts of first-degree intentional homicide with the very obvious significant weighty sentences. The habitual criminality alone would add 120 years. The dates start on March 26, 1989, so all of them, all 12 counts, are under life means life. So the temptation to this defendant to take flight were he somehow to secure freedom would be immense. Under those circumstances, I would suggest to the court might wish to add to the bail of $1 million. Should be in cash, of course.
Mr. Boyle?
No argument. And that would be waived, obviously, if there is nothing there to test, that he wishes to have those parts released and not be retained. I would furthermore state for the record that I have this date contacted. If one reads the criminal complaint, much of the identification is done by a forensic odontologist. I am confident that that odontologist has retained sufficient information for which somebody in the future need be, or if that time ever came, can review his work product, determine whether or not he is correct in his conclusions and opinions. I have no reason at this time to proffer why Dr. Jensen has to retain anything further, and obviously, therefore, they can use their own...
It gets stranger. Look at the physical distance between Dahmer and his defense attorney, Gerald Boyle. In the close-up shots, Dahmer is sitting right next to Boyle, whispering directly into his ear. Yet in the wide camera angles supposedly capturing the exact same moment, the spatial distance between them drastically changes. How does the seating geometry shift this dramatically in a tightly controlled courtroom setting unless this scene was staged or shot across multiple takes? Beyond the visual glitches, listen to what defense attorney Gerald Boyle actually proposes to the court. Just 15 days after Dahmer's arrest, before a formal plea, before any trial strategy is established, Boyle suggests returning key forensic biological evidence to the victims' families.
Mr. Boyle?
No argument. and that would be waived, obviously, if there is nothing there to test, that he wishes to have those parts released and not be retained. I would furthermore state for the record that I have this date contacted. If one reads the criminal complaint, much of the identification is done by a forensic odontologist. I am confident that that odontologist has retained sufficient information for which somebody in the future need be, or if that time ever came, can review his work product, determine whether or not he is correct in his conclusions and opinions. I have no reason at this time to proffer why Dr. Jensen has to retain anything further, and obviously, therefore, they can use their own discretion in returning whatever they wish to return to the members of the family.
In a high-profile homicide case, releasing crucial biological evidence 2 weeks after an arrest defies standard legal protocol and ruins chain of custody requirements. Why would a veteran defense attorney rush to dispose of foundational forensic evidence before the trial even begins? Mismatched personnel, shifting seating positions, and unprecedented legal moves. Was Dahmer's second court appearance a live judicial proceeding or a rehearsed broadcast? Tell us what you see in the comments below. Subscribe to Dahmer Analysis and join us as we continue to dismantle the official story. See you in the next installment